Contract law recognizes two kinds of mistakes about facts existing at the time a contract is created: mutual mistake and unilateral mistake. We will first discuss mutual mistake. Technically speaking, mutual mistake is not a defense against enforcement of a contract, unlike duress or misrepresentation. The defenses allege that the bargaining process has been tainted by one party's misconduct. Mutual mistake, however, can occur even in the absence of wrongdoing by either party. Section 152 of the Second Restatement addresses mutual mistake. It provides that when both parties are mistaken about a basic assumption on which the contract was made, and that mistake has an adverse material effect on only one party, the adversely affected party may void the contract unless he bears the risk of the mistake. What would be an example of a mistake as to a basic assumption that has a material effect on one party? Let's consider a hypothetical. The facts are based on the Sherrod case in your text, which may or may not have been assigned reading for you. In that case, Sherrod had entered into a contract for the excavation of a construction site. The price for excavating the site was set as a single lump sum. There was evidence that both parties were mistaken about the amount of dirt to be excavated, both parties believing that 25,000 cubic yards needed to be excavated, when in fact the amount was twice that. Because the contract was for excavation, the amount of dirt to be excavated was a basic assumption that affected the price charged. Moreover, the mistake had a material, adverse effect on Sherrod, who had bid the job assuming a certain amount of dirt had to be excavated, and now was going to have to perform twice as much work. So it seems that Sherrod would have the option of voiding the contract, unless it bore the risk of the mistake. What does it mean to say a party bears the risk of the mistake? That question is addressed in Section 154. That section provides that a party bears the risk of mistake in three instances. First, where the agreement of the parties allocates the risk to one of the parties. Second, where one party assumes the risk, that is, he knows he has only limited information with regard to some of the surrounding facts, but treats his limited knowledge as sufficient. And third, where the court allocates the risk to one party because the court determines that it is reasonable under the circumstances to do so. Let's consider instances of each of these three circumstances. Assume that the contract provided that it was Sherrod's responsibility to determine the amount of dirt to be excavated. That would be an example of the contract explicitly assigning the risk of a mistake about the amount of dirt to be excavated to Sherrod. If the contract contains such a provision, it is unlikely that Sherrod would prevail under the doctrine of mutual mistake, even if the other party had said something like, "I estimate there's about 25,000 cubic yards to be excavated." That is because the contract placed the responsibility for determining the amount of dirt on Sherrod, and thus it was his responsibility if there was a mistake to the amount. If the other party deliberately lied about the amount, as opposed to simply expressing an opinion, then we would not be dealing with mutual mistake, but rather misrepresentation. Similarly, even if the contract did not explicitly allocate the responsibility for determining the amount of dirt to be excavated to Sherrod, if Sherrod could estimate the amount to be excavated, but instead of doing that calculation, he relied on the other party's estimate, which turned out to be mistaken, the risk of mistake could be allocated to Sherrod under the second prong of Section 154. He knew he had limited knowledge as to the amount of dirt to be excavated, because he hadn't done the calculation, but he treated his limited knowledge as sufficient when he relied on the other party's mistaken estimate. Finally, under the third prong of Section 154, a court could conclude that it was reasonable under the circumstances to put the risk of mistake on Sherrod. For instance, depending on the evidence, a court could find that Sherrod had the expertise to calculate the amount of excavation needed, that the other party did not have such expertise, and that a reasonable excavator would never have relied on someone else's estimate. Conversely, again depending on the evidence, a court might find that excavators regularly relied on estimates provided by the landowner or general contractor when bidding a job, in which case the court might well conclude that Sherrod did not bear the risk of any mistake, and so could void the contract. This would leave Sherrod free to recover in unjust enrichment for the market value of the excavation actually performed. So even though the doctrine of mutual mistake might apply to the Sherrod case, based on the facts, it is not at all clear whether Sherrod would have prevailed under that doctrine. Law and Economics has a helpful take on the issue of loss allocation in situations of mutual mistake. It would argue that it is most efficient for the parties themselves to allocate the risk of any mistake, and that a court should defer to the party's decision. Absent contractual agreement, however, it would argue that it is most efficient to place the risk of mistake on the party that was in the best position to anticipate and either prevent the mistake or ameliorate the effects of any mistake. Often, this is the party who occupies a position of superior access to information. This could be the party with special expertise related to the subject matter of the contract, or in cases involving land, it could be the landowner, who generally has better access to information about the land being sold. Consider this question. Is this law and economics approach consistent with the outcome of the Lenawee case in your textbook?